Good morning, everybody. Welcome to the Zaller Law Group webinar discussing how to implement the workplace violence prevention plan for most California employers, going to be required by July 1st. And we're going to walk through some of the parameters today on what's required as part of the plan and discuss some updates, some current updates as well. Cal OSHA published a few FAQs just yesterday as well that we'll be discussing today, clarifying an employer's obligations to develop and publish these plans. We'll let everybody start logging in here. I see the number increasing, so we'll give everybody a few minutes to log in. And just as a reminder, this is not legal information. If you have any specific questions, feel free to reach out to us or your attorney. And the webinar, any recording of this is prohibited as well. We've got our excellent team of lawyers on the webinar and prepped today. It was a lot of preparation, getting ready, and the materials ready for today. So I want to shout out to Anne, Vanita, and Pooja. Pooja really took the laboring oar on the materials today and spent a lot of time getting this ready and helping some of our clients on this issue as well. So want to really appreciate their hard work and preparing for today and getting this all ready. Now, Pooja, do you want to discuss the MCLE and SHRM certification?
Yeah, thank you, Anthony. So we are recognized by SHRM to offer the PDCs. So if you are trying to get this for your SHRM CP or SHRM SCP credit, please email Jeremy. His email is right there, and he'll send you over the activity code. And we are pending approval for California MCLE. So if you're an attorney, you're in-house, you're at a law firm, whether you do employment or not, but you need to get those MCLEs in, please also email Jeremy and we'll get you over that credit information once we have our approval.
Yep. So yeah, and if you're an attorney, we see there's a lot of attorneys that are on the webinar that might not practice employment law, or even if you do practice employment law, it's great to get the MCLE. We're working with the state bar to provide that. So please email us and make sure you get that MCLE. Great. So just jumping into the issue today that we're talking about, the violence prevention plan is required for nearly every employer in California as of July 1st. Every employer is going to have to implement one of these and publish it and take a lot of different steps for training, record keeping, and just maintaining logs. And then at the end of the webinar today, I'm going to be talking about some restraining orders under SB 428, and employers' application of applying for restraining orders for employees that pose a threat to the workplace, or even third parties that pose a threat to the workplace, and what their options are with the restraining orders. It's separate from the violence prevention protection plan, but it's another option that employers should be thinking about. And so we're focused on this today. We're going to be touching on a few different topics as well, including the IIPP. And I think we'll have a few questions come up on that. We're trying to keep this really focused on the violence prevention plans and limited to that. So if we have some other topics, we'll talk about those on the side, but we're not going to get into specific questions about the IIPP and how to develop that, but we will be discussing that as it relates to the workplace violence prevention plans. So this new law that was passed last year has this requirement come into place, as I mentioned, July 1st. Nearly every California employer will have to develop a workplace violence prevention plan. And the law is pretty stringent on what's required in these plans. And with that said, though, with the detail that it sets out, it's pretty easy to comply. And now we've got a form that Cal OSHA has published as well that employers can use and fill in the blanks to meet these obligations. And we'll be talking about that form. And we've also posted a link in the webinar chat here to a Dropbox with all of our handouts that we'll be talking about today as well. So feel free to click that link and look at those as we're discussing the requirements here today. As I mentioned, this deadline's coming up quickly, July 1st, 2024, and it applies to nearly every employer in the state of California. So here's the labor code section 6401.9 that has the requirements. And their penalties are very, very dramatic and can be an issue for employers that don't comply. And I was thinking about the IIPP and just having the plan. This is something when Cal OSHA comes into the workplace that they'll be asking for right off the bat, even if they don't have anything specific they're investigating and they're checking in on a workplace. They're going to ask for the IIPP and the workplace violence prevention plan. And if the employer doesn't have it, you're looking at these penalties, which are significant. So employers need to heed this and develop the plan and just get on it before July 1st. As I mentioned, it applies to all employers across California. There's a few exceptions here. I think we've got 6 or 7 exceptions. Most of the exceptions won't apply to anybody on the webinar today, but I'll talk about them. But I think the first 3 here on this slide are most prevalent to the audience today on the webinar. So employers that have employees teleworking from a location of the employee's choice and that location is not under the control of the employer, that you don't have to have a violence prevention plan for those employees teleworking in those places that they're working from, if they're working from their home and the employer has no control over it. And also where the employment has less than 10 employees working at any place in any given time that are not accessible to the public. And that's the key issue there. So if it's less than 10 employees and it's closed to the public, and I think you should be pretty strict on this reading where, even if it's open to the public, but nobody comes in routinely, it's still open. The public could come in. It needs to be a secure, I would argue, it's locked. You have to have a pass, ID card, something like that to access that location. Then that would be excluded from coverage of the new law. And then healthcare facilities, there's a lot of different definitions of healthcare facilities that are carved out. They've got their own standards that they need to implement. So number 3, I discussed that here, and as well as number 4, different healthcare facilities covered by the California Code of Regulations. And then 5 and 6 pertains to Department of Corrections, Rehabilitation, and law enforcement agencies, which I don't think we have on the webinar today, but wanted to mention it. So those 6 are the only exclusions that apply, though. So as I mentioned, it's going to cover most employers here in the state of California. And with that, let's jump right into the details of setting up the plan.
Good morning, everyone. I'm going to be covering what is workplace violence and understanding what qualifies as workplace violence so you can know how to implement this plan. It's defined as any act of violence or threat of violence that occurs in a place of employment directed at an employee. So key thing to note here is that it must be directed at an employee. Specifically, workplace violence includes use of physical force against an employee that results in or has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether the employee actually sustains an injury. An incident involving a threat or use of a firearm or other dangerous weapon, including the use of common objects such as weapons, regardless of whether the employee sustains an injury. So injury is not required as an incident for an incident to be considered a workplace violence. However, any lawful acts of self-defense or defense of others would not qualify as a workplace violence incident. What is a threat of violence? A threat of violence can be any verbal or written statement that conveys an intent or that is reasonably perceived to convey an intent to cause physical harm or to place someone in fear of physical harm, and that serves no legitimate purpose. So even though there may not be an actual threat, but the standard is if it is reasonably perceived as a threat by the individual employee, it would qualify as a threat of violence. Threats can be verbal or written statement, and they can include text messages, electronic messages, social media postings, or other online posts, any behavioral or physical conduct, and includes a threat of physical force that results in or has a high likelihood of resulting in an injury. There are 4 types of workplace violence that the statute delineates. So the first type is an unrelated person with a criminal intent, a person who has no legitimate business at the work site, and this includes violent acts by anyone who enters the workplace or approaches workers with the intent to commit a crime. The second type would include of workplace violence by an individual with relationship with the business, such as by customers, clients, patients, students, visitors to the workplace. And type 3 would be worker-on-worker violence. So this would be by a present or former employee, supervisors, managers, or anyone who's employed by the employer. The fourth type would be personal relationship, a person who does not work but has or is known to have had personal relationship with an employee. Type of workplace violence must be recorded on the violent incident log, which I'm going to cover in a little bit. So when recording the incident, it must be recorded as falling in one of these 4 types of categories of incidents.
Thank you, Vanita. I'm going to discuss how we develop this plan. We know we have to do it. We know there's different types of workplace violence incidents, but okay, now what do I do? What's the first step? Well, the first step is, do you have an injury and illness prevention program? As a reminder, generally all California employers are required to have one. There are some very limited exceptions, but for the most part, most of the employers here are going to need one. So if you don't already have one, that's a good place to start. Cal OSHA has a model. Cal OSHA's website has some information on that, as well as we'll discuss it a little bit here. But as Anthony mentioned, our focus here is going to be the workplace violence prevention plan. So the first thing you want to do is you want to download and save the model workplace violence prevention plan. This is a model that has been provided and developed by Cal OSHA. It includes all of this information that we are going to go over today, and it allows the employer to sit down, figure out what information they need, and plug that right in. This plan can be a standalone document, it can be a separate prevention plan, or you can add it on to your injury and illness prevention program. So if you already have one, you can add it to the end of that. Or if you don't already have one, you can develop both of these at the same time. The first thing that you want to do is you want to identify the individual or the individuals who are going to be responsible for implementing this plan. You can have more than one person responsible, but as you'll see on the plan, you will need to identify exactly who is, what role they have and what their specific titles are. And you may want to use the same individual that's responsible for your injury and illness prevention program, your IIPPs, because there is a lot of overlapping information. So there are 12 key components that I'm going to go over that need to be in your prevention plan. These are, again, all on the model or the Cal OSHA model plan, and they outline exactly what information you need to put in there. So the first one is responsibility. And this is what I discussed earlier. It's the name and the title of the persons responsible for implementing the plan. Anthony, could you go to the next slide, please? There we go. And here you can see the plan itself has a box ready for you to fill in, identifying the person who's responsible, what their job title is, what specific responsibility they have, and their contact information. Again, you can identify multiple people, but you do need to fill out that column that talks about their responsibilities. What specific responsibilities do they have? And Anne will talk about it later, but there is you need to ensure that the person doing your training is well versed in this prevention plan. So that is something to consider when you're identifying the individuals that are going to be responsible. The second element is that your employees need to have an active involvement in your plan. So what procedures are you going to put in place to ensure that there's active involvement in developing and implementing this plan? So will you have ongoing safety meetings? What's going to be addressed at these meetings? How can employees submit suggestions for training? And how will employees submit reports of workplace violence incidents, including who they report it to, who will handle the investigation? The third element is to ensure that all employees, and that doesn't just include your supervisory employees, this includes your non-supervisory employees, will comply with the plan, including procedures to ensure that there is a prohibition against retaliation against employees who report workplace violence. So you may want to determine what steps you're going to take to ensure that the employees are complying, whether you need to retrain employees that have deficient safety performance, whether employees who violate or do not comply with the plan are going to be disciplined, and whether you may want to reward or highlight employees who have exceptional safety performance. The fourth item is communication with your employees. How are you going to communicate with your employees? How can employees communicate information to the employer? Is there going to be a cell phone alert? Do you have an email communication? Is there an alarm in the workplace that will ring in the event of a specific workplace violence? And as a reminder, you do not want to prevent your employees from accessing their cell phones to seek emergency assistance. And in fact, employers are prohibited from enforcing personal cell phone policies if the device is being used during an emergency condition for safety reasons. So you can have your cell phone policies preventing employees from using their personal cell phones, but if there is an emergency condition, that needs to be carved out as an exception. The fifth element here is employee compliance. A coordination with other employers. What are the methods that the employer is going to use to coordinate the implementation of the plan with other employers? So for example, if you're in a work site that has multiple employers, you're in a building that has different offices, how will you coordinate with those other employers to ensure that these plans are in place? Perhaps your evacuation plan needs to be coordinated with your building, which staircase employees need to use in the case of an evacuation or any other violence incident. The sixth element is workplace violence incident reporting procedure. How are employers going to accept and respond to reports of workplace violence? How does the employee report it? Who does the employee report it to? And similar to when employees report incidents of harassment or unlawful conduct in the workplace, you want to provide alternatives. You want to allow the employee options of people that they can go to and report this workplace violence incident to. There is no requirement to have a system in place that employees can submit incidents anonymously. However, that may be a good practice to have. In certain incidents, an employee may feel more comfortable reporting something anonymously rather than with their name. The seventh element is what are the protocols for emergency situations, including communicating with emergency contacts. So how is the employer going to alert employees in an emergency situation? What are the procedures for evacuation or for sheltering in place? How can employees contact staff, security personnel, or law enforcement? Who is the emergency contact for the employer? What if your work site doesn't have cell phone service? What if you're in an area that, the cell phones just don't work great? What procedure can employees use to contact emergency personnel? Is there a landline that employees can use? These are the type of things you want to consider when identifying your emergency response procedure. The eighth element is identifying your workplace hazards and evaluation. Now, this is something that is going to be ongoing, and it's something that you will be doing on a yearly and periodic basis, but this is a place where to start. At the beginning, when you are developing your plan, you want to conduct a risk assessment to identify potential hazards. Things you may want to consider: is there adequate lighting? Do your employees need to take out the trash at the end of their shift, and is the alleyway really dark? That may be something you need to consider. Maybe you want to implement a buddy system so employees aren't going out by themselves. Are there video surveillance? Is there alarms? Are there locks? Where can employees go in the case of an emergency? And are employees trained on how to de-escalate violent or potentially threatening situation? So you want to have a procedure set up that on the outset on how you're going to identify these hazards, and you're also going to want to identify when you're going to continue to do these evaluations. Are you going to have periodic inspections? Who is going to conduct these inspections? Are you going to be testing, if there's an area that maybe there's not adequate lighting, is somebody going to be testing it every 6 months to make sure the light bulb is working, or every year to make sure that your alarms are working condition? Number 9 is the correction. So this is the procedure on how to correct those hazards. So how are you going to do that? What actions are going to be taken? What if there's an imminent workplace hazard? What steps will be taken there? In the case of a hazard that can be immediately corrected versus a hazard that cannot immediately be corrected. So you want to identify some of the corrective measures specific to this workplace. We talked about some examples, but some additional examples may be limiting cash on the premises, or having certain areas that are controlled access for employees only. You also may want to establish and enforce workplace safety policies if you don't already have one, such as a no weapons policy. The 10th element is procedures for post-incident response and investigation. So what happens after a violent incident occurs? And Vanita is going to talk a little bit later about the violent incident logs. So as you're doing that log, this goes hand in hand. How are you going to be doing that investigation? Who's going to be filling out the log? What documents will you be reviewing? Who's going to be interviewed? And again, who is going to record the incident on that violence incident log? Number 11, and I'll touch on this briefly because Anne is going to go into detail about what training you're going to provide to your employees. But you want to identify in your plan who is going to be trained, which is everybody: your managers, your supervisors, all your employees. When they're going to be trained, they need to be trained on there's very specific requirements of when they need to be trained on a yearly basis, again, after additional hazards are identified, and also when there's a violence incident, and what items are going to be included in the training. And finally, your plan needs to include a procedure for reviewing and revising the violence workplace prevention plan. So you need to be reviewing this plan to make sure it's being effective, revising it as needed. At minimum, every year when you're doing your training is a great time to review the plan, make sure that everything is in there. If you find a new deficiency, if there's a new workplace violence incident, when you're doing that training again, revise the plan, add in those additional hazards you've identified, add in the new corrective measures that have been added into into the next steps. And finally, well, what do we do if we are an employer that has multiple locations? I have 3 different locations. Generally, all of our locations are the same. The setup is the same. Our general procedures, policies are the same. The OSHA allows you to have one plan for all of these work sites, but you want to be sure that you are making it customized to each plan. So the key areas you want to focus on are those specific hazards, the corrective action, and your contact information is going to be customized for each location. So start with maybe your first location or your biggest location, develop your plan, and then customize it, change the information that needs to be changed for each location. And with that, I'll turn it over to Anne to tell us more about our annual training to add to our list of trainings we have to do every year.
Thank you, Pooja. So first of all, Why is training important? Well, it is now required under the law. Employers must develop and provide effective training as part of the workplace violence prevention plan. Training, also satisfies part of the employer's obligation to have that employee involvement in developing and implementing the plan. And, remember that employees can be a really good source of identifying potential workplace hazards and ways to minimize those hazards. So this is your training sessions is a really good opportunity to delve into those issues. And, training, it's good communication. It effectively communicates, what are the procedures in place for workplace safety, creates a better working environment, educates the workforce on here are the procedures. This is how we're going to follow them in this scenario or another scenario. And of course, last but not least, the effective training is going to be evidence that you are complying with this new law, which is rather comprehensive. And that compliance issue may come up if Cal OSHA is conducting an inspection on your premises, or possibly they're investigating some type of claim, whether it is related to workplace violence or not. They could, in fact, ask for your training logs and all your records relating to workplace violence. And keep in mind that it is also important that your training and your record keeping may in fact become evidence in a civil action. And that may in fact bolster the defense in the case. So how often do you have to provide training? Training must be provided to all employees on an annual basis. And that means right now that the first trainings have to be completed before July 1. So you should start planning early for that training is my advice. After that, training is required every year. And employers are also required to keep detailed training logs, just like you keep the detailed training logs for your IIPP program as well. So training sessions can take many forms. It can involve presentations, discussions, practical exercises. There's no set hourly requirements for the training. It's so long as it covers all the necessary topics, and the law is rather specific on what must be included in the training. And also be mindful that there will be situations where additional training may be required. That's where you may have a new or previously unrecognized workplace violence hazard that has yet to be identified. And anytime that there is a change made to the plan, and probably anytime that there is a serious violent incident. So the law is very specific on what must be included in this training. You're going to want to first let the employees know how they can obtain a free copy of the plan and how they can participate in its development and implementation. You'll need to go over the definitions and requirements of a workplace violence prevention plan. We've got a couple of handouts that can assist you with this training. We've got sample key definitions and a potential topic list for your training. When you're giving the training to employees, you want to give very specific workplace violent hazards to that job site, those employees' duties. Also cover the corrective measures that you have put in place to reduce workplace violence hazards, and how employees can seek assistance or if there is or how to report or respond to a potential incident of violence, and strategies of how to avoid any incidents, including physical harm. It's also important that the employees receive information on how to report workplace violence hazards or incidents or any other concerns that they may have with that. And very important that employees know that they can report these incidents without any fear of reprisal, adverse action, or any type of retaliation. Employees should be given information about the violent incident log and how they can obtain a copy. And lastly, in line with the employee involvement that these new laws have as part of a theme, the training needs to include an interactive question and answer session with someone who is knowledgeable about the plan. So some of my best practices that relate to training requirements, I would start preparing your training materials early on as you're developing your plan. There's a lot of overlap. It's more efficient in your time, and there's a lot of forms also that you can be preparing in conjunction with the actual preparation and development of the plan. The training must be conducted in a manner that is easy to understand and match the employee's education, reading skills, and language. Again, you could look at some of the resources and the handouts that we have for that. And then I would also seriously consider combining the training for your workplace violence prevention with your injury and illness prevention. There's a lot of overlap. It may be more efficient for your employees that way. And again, critical that you maintain the detailed training records. If there is an issue on training, if Cal OSHA gets involved, you will absolutely be asked for that training log.
Great, thanks, Ann. And before we move on to Vanita with the violence incident logs and how to maintain those, I had one comment here too. Yeah, I agree with your best practices, Ann, and would also have employers think about doing this training in connection with the sexual harassment prevention training as well. So maybe at the end of that training, but you need to watch, that's only required once every 2 years, and this is required every year. So there's an ongoing training requirement now that California employers basically need to be complying with every year for their employees. So need to just make that part of the routine and build that into your practice. But I think it'd be good if you get all the employees already together for the harassment prevention training. It'd be a good time to address that as well.
Anthony, I think that's a great point. And I should mention that the training for the illness injury prevention is not annual, it's every 2 years. So it's on track with the sexual harassment training as well.
Yep. Great. So with that, we'll hand it over to Vanita to discuss the violent incident logs.
Thank you, Anthony. So violent incident logs. I'll be covering, what is a violence incident log and what information goes in it and what to be included in it. It's a log of all incidents of workplace violence, regardless of whether the incident resulted in an injury. So it follows the definition that I covered earlier on. Where does the information that is documented in the logs come from? This is going to come from the employee's statements, witness statements, and your investigation findings. Be careful when you are completing the log that the log must exclude personal identifying information that would identify any person who is involved in the incident, such as the person's name, address, email address, phone number, social security, or any other information that either alone or in combination with any other publicly available information would reveal the person's identity. So it needs to make sure that you exclude all of that information. Next slide, Anthony. What must be included in the violence incident log? So it must include, obviously, all the relevant information, such as the date, time, location of the incident, what type of violence it was, which I covered, whether it was 1, 2, 3, or 4 that I covered earlier under the definitions, a detailed description of the incident, and a classification as to who committed the violence. And you have to be very specific. What was the relationship between the perpetrator and the victim? Was it a client, customer, family member, friend, stranger? A classification of the circumstances at the time of the incident, including what was the employee doing at the time? Were they doing their regular job duties? Was the place where the incident occurred, was it lit or was it dark? Were there other people around, or was the employee isolated? And was the employee understaffed? Additional specific information that must be included is classification of the location of the incident. So did the incident occur at the normal workplace, community setting, parking lot, or outside of the workplace? Additional information as to the type of incident, including whether it included any of the following, such as, was it a physical attack without a weapon, fighting, choking, grabbing hair, or was it an attack with a weapon, type of weapon? Was it a threat of physical force or the threat of use of a weapon or other object? Was it a sexual assault or a threat of the same? Or was it an animal attack? What were the consequences of the incident? So was security there, or was law enforcement involved? What actions were taken to protect the employee from any continuing threat or other hazards identified as a result of the incident? And the log finally must also include who completed the log. So that would include the name, the job title, and the date that it was completed. So these logs, here, we have a sample here that you can use. Now, Cal OSHA has a log included, as Pooja mentioned, in their model workplace violence prevention plan, but employers can develop their own violent incident log as long as the information recorded on the log complies with the requirements that we have discussed that are listed in the law. With that, I believe Anne is covering the records keeping requirement.
Yes, thank you, Pooja. So, in addition to the Workplace Violence Prevention Plan, Senate Bill 553 requires 4 other categories of records that employers must maintain. Workplace violence hazard identification, evaluation, and correction records must be created and maintained for 5 years. The violent incident logs that Vanita talked about are to detail separate violent incidents, and they must be maintained also for 5 years. Records of workplace violence incident investigations conducted in accordance with the employer's plan also must be maintained for a minimum of 5 years. And records on workplace violence prevention trainings are to be maintained for at least 1 year. And those training records need to be detailed, including the dates of the training, the contents or a summary of the sessions, the names and qualifications of the persons conducting the training, and the names and job titles of everyone attending the session. I noticed that we had a question, do the employees have to sign off on that? Right now, as written, the law does not require it. If you keep the people attending on a log, that is sufficient. No required certification is necessary. And like I had mentioned earlier, the type and nature and the length of the training is going to be dependent upon the nature of your operations, the size and nature of the classification of your workers. So that is something that you, in your planning for this program, should take into consideration.
And to jump in there too, I saw another question. I think they were asking, is Cal OSHA going to offer an online training course? And I don't think so. They may, but this is very specific to your workforce. You have to address the specific threats to your workforce. So it's going to be hard to come up with a generic one. So I don't think there's going to be a generic training that you can show to your employees through Cal OSHA. It's going to be very specific and up to the employer to develop.
So if we can move on to the next slide. So are there other records that employers must maintain. So Pooja has gone over in detail the plan itself. It must be in writing. And it must also be accessible to employees, authorized employee representatives, and to Cal OSHA at any and all times. Be mindful of that. One of the FAQs that Cal OSHA just published yesterday talked about this easy access to the plan, and that might be dependent on the nature of your work force. So some options in making that accessible that you can consider is posting it in a common area, or having it in a binder, or putting it on the company website. Also yesterday, the FAQs, and I highly recommend that everybody take a look at those FAQs. Cal OSHA recommended that postings on workplace violence prevention be displayed in a conspicuous place where the employees have easy access to that. In the common areas, the typical place where you would be posting most of your HR posters as required. And you also have the option of distributing, workplace violence prevention information to the workforce. I noticed we had a question about on that district, if the fact sheet that is published by Cal OSHA would be sufficient to satisfy the training materials that you would need to distribute to the workforce. There's nothing specific on the website saying that or in the law, but I would think you would need possibly a little bit more information than the fact sheet. If it's a very small workspace, a workforce, that along with a couple other items may satisfy that. But it's really going to be, dependent on your individual premises. And, that's why it's so important to delve into assessing the hazards, conducting, the inspections of your work areas, and coming up with a plan. Employee requests. If you get an employee request for records involving workplace violence, you must respond within 15 calendar days. Those requests could be made verbally or in writing, and the copies of the documents have to be provided to the employee free of charge. And again, this slide here is just going over how long to maintain the records, a minimum of 1 year on all training records. You may want to consider maintaining those records for longer. They may become useful in other investigations, or just ongoing to have that record. And unlike the IIPP record retention that only has a 1 year, there's these other records that must be maintained for 5 years. So it's really critical that you keep up to date with these record requirements. Like Anthony had mentioned, when Cal OSHA comes to your premises, and it may have nothing at all to do with workplace violence, first thing they're going to ask for is your IIPP, and now it's also going to be the workplace prevention plan as well. And so even if they find nothing else, everything is all in order, you may be cited and fined for the lack of the documentation. And again, so these new requirements for record keeping is not a substitute for your legal responsibility to immediately report to Cal OSHA any and all serious injury and illnesses. So if you have a workplace violence incident that also results in a physical injury, just recording it on the violent incident logs that Vanita talked about is not going to be sufficient, nor will it be compliant. You must also record that on the Cal OSHA 300 logs for the injuries. And I put together a few best practices that I think you should keep in mind with record keeping requirements, though not set forth in the new law. You should take a look at your handbook and review the workplace violence policy in your handbook. If that needs to be updated to become consistent with these new regulations, you should do that now. If you in fact don't have a workplace violence policy in your handbook, I highly recommend that you create one now. And my number one tip for these record keeping requirements and everything related to this plan actually is to really start working on this early and planning early. Get someone designated, have that person get up to speed on what the requirements are. This is a very comprehensive regulation. It's going to take you some time to do it. So get a head start, get those logs and templates together for your incidents, for your investigating, your correction documents, your training documents, and really take advantage of the wealth of information that Cal OSHA has on its website. I recommend use that plan. It's an essential framework that has been blessed by the department. Use resources we've given you here in the slides and the handouts. If you start early and combine all of that stuff, you're on your road to making sure that you meet that July 1st deadline. And I've got some additional resources here, some links to Cal OSHA. We've got the model plan itself for the workplace violence. There's guidance on how to protect employees from workplace violence. There's the frequently asked questions. There's 2 fact sheets, one for employers, one for employees. I would take a look at all of this resources and really become familiar with the website itself. And I think we had a question that somebody asked if those fact sheets were in Spanish yet. I have not seen them, but I would keep an eye out on the website. We just got FAQs yesterday. I expect there to be a lot more. And one thing I would point out is that while these are new requirements, Cal OSHA is not required to adopt actual minimum standards for this law until December 31st of 2026, I believe. So between then and now, there's going to be a lot of unanswered questions, and keep an eye out for that. Again, this is like, as Anthony mentioned before, many of these things are going to be fact dependent on the nature of your workforce and your work premises as well.
Great, thanks, Ann. Yeah, the resources, Cal OSHA has done a really good job just with having the forms for employers to start with. And again, the employer still has to tweak it and add their individual information for their locations, but it's a great starting point and you don't have to start from scratch. So they've done a really good job to help employers, and we're still out a ways out from the July 1st. It's quickly coming up, but I expect to see more FAQs from Cal OSHA as we get closer to July 1st, as more of these questions get posed. And there are still a lot of questions out there that the law wasn't entirely clear on. So we'll keep an eye out on Cal OSHA for that clarification. Now, separate from the workplace violence prevention plan requirement, I wanted to talk about restraining orders in the workplace. I thought it was relevant to this topic. Just touch on this really quick, and then we'll wrap it up with a few key takeaways from each of the attorneys. We'll talk about that here in a minute. But the current law for California employers, they may seek temporary restraining orders on behalf of an employee when the employee has suffered an unlawful violence or credible threat of violence from any individual. I've got the elements spelled out on this slide here. So the employer can go in and seek a restraining order, but right now it has to be connected with some violence or credible threat of violence. And we've got a link there at the bottom on how employers can seek a TRO as well. And it's something employers should keep in the back of their mind as a tool to prevent violence in the workplace. And I think it goes to employers should be thinking about, like, what steps should we be doing to protect ourselves from civil liability? Are we doing enough to protect our employees? In applying for these restraining orders, if there's a credible threat, is a tool employers should keep in the back of their mind and use. It's actually pretty easy to go in for a TRO. So yeah, now the law is becoming easier as of January 1st, 2025. This law, SB 428, basically changed that standard. It doesn't have to be connected to violence. It could just be connected to harassment. So if an employee is being harassed, and I have the definition set out here on this slide, then the employer has the opportunity to go in for a TRO. And here under this new law, the employer must allow the employee the opportunity to decline being named in the order before filing the petition. So, yep. And there's some other provisions here, if it's a legally protected speech, yeah, the employer can't go and file a TRO against the individual. But it is giving employers a lot more opportunity to go in for the TRO. And again, that law takes effect at the beginning of 2025. So something to keep in mind. Here we've got the list of the forms. I think we've already discussed that. I think we have those in the handouts as well in the Dropbox link, so you can download those. And that basically wraps it up for what we were going to cover. I wanted to just throw it out to everybody, some key takeaways before we conclude the webinar. And I'll lead us off. But I think there's like 4 things that employers really need to keep in mind here going forward with this new requirement for the violence workplace prevention plans. Number 1, you've got to have a written plan. And you need to designate somebody to take charge, the lead on this, and develop the written plan. 2, remember there's a training component every year that needs to be built into your process and procedures. So whoever's taking the lead on the written plan should be following through with the training as well. Number 3, keep in mind the employees have the right to request these logs and the records, and you've got a short 15-day time period to turn around and provide those. So have somebody ready to go and respond to those requests. And then 4th and finally, as Ann mentioned, there's these reporting obligations to Cal OSHA, and keep that in mind. When an incident happens, somebody needs to be thinking about filing the report with Cal OSHA. And usually these are pretty dramatic types of circumstances. So, there's a lot of other things going through everybody else's mind and legal actions probably and things like that. So somebody needs to be tasked with, does this need to be reported, and be in charge of doing that. So any other takeaways, I'll throw it out to the group as well.
I think one thing I wanted to reiterate is the definition is, a violent act or a threat of violence that's directed at an employee. So if you have visitors and if you have 2 visitors fighting on your premises, that wouldn't be a workplace violent incident. So just wanted to clarify that because I saw some questions coming through in the chat and in the questions about that.
Great.
Yeah, and I have 2 things. One is coming in from some of the questions is, we're based out of state, but we have employees in California. We have employees on different sites. The law is that if they're working in California, the employer has the responsibility for providing this training and having that plan. So if your employees are here in California and you don't fall into one of those exceptions, you want to be sure that you are getting these plans in place and getting that training done and out there. And then I think something else that Anna had mentioned that I wanted to reiterate is the training. There is no set amount of training. There is no specific template or anything, but it does need to include all of these topics. And so you just want to be sure that you are covering all of the different information that is in there, and also soliciting information from your employees, whether that's holding some safety meeting or asking your employees what type of hazards they see, what type of concerns they have, to solicit their concerns and to be able to include that in developing your plan and your training. one of the requirements for Cal OSHA is to have the engagement from your employees.
And, you know, my big takeaway, it still remains the same thing, is just start planning now for this. Use all the resources, and it's just a roadmap, and it's going to get you there. Don't get overwhelmed with all these requirements. Don't think that you have to publish, you know, War and Peace on the training materials. It's really going to be dependent, you know, you can have the handouts, you can have the plan itself available to the employees. There's a question about whether can you give digital copy? Absolutely. You know, what makes sense for you. But yeah, just spend the time developing the plan, and that's the key to getting this completed. And just don't wait till the last minute.
Yep. Great, thanks. You know, and before we wrap it up here too, if you found the webinar helpful and we've spent a lot of time preparing it, you know, please consider giving us a Google review here. We generally haven't paid attention to the Google reviews and asked for that, but if you've got time to do that, we'd appreciate that. So you can do that here at this link or the QR code. And also you can submit an evaluation at these links on this slide. And as Pooja mentioned at the beginning of the webinar, there is SHRM credit, and we do have this pending for MCLE for the State Bar of California. So the attorneys on the webinar should email us as well, and we can put you on the list to get the MCLE. So that would be great. And here's the email for the attorneys, for jrogers@zollerlaw.com. And yeah, we had a few questions coming in. How could you stay informed for future webinars? We are trying to do these webinars about once a month. So you can send Jeremy an email, jrogers@zollerlaw.com, to be on our newsletter and get information about upcoming webinars as well. So hope you take advantage of that. And you can also subscribe to our blog here. And we are posting a lot of information out on YouTube and on our podcast. So you can look us up on that as well. And I think that gives us 2 minutes to wrap it up here. We're a little early today. I was a little nervous. We had a lot to get through. Any final question that you guys saw that we should address with the remaining time here?
Yeah, I think, Anthony, we got a couple of questions about, well, you know, Anita talked about the violent incident log. Don't include your personal identifying information. Well, how do we do that? How do we, you know, do this without including names? And, you know, and Vanita, if you want to jump in, but I think that it's including the information about the person. So is this an employee? Is this a friend of the employee? Is this a customer? But you do want to avoid putting that name or personal identifying information on those logs, because those could be, you know, those can be pulled by employees or Cal OSHA.
Yeah, I agree, Pooja. I think it just identifying the class of persons involved, you know, employee versus customer, employee versus employee, perhaps their job title, without giving away too much, that would be sufficient.
And then sort of on another topic here, I guess we have a minute or so left here. I would say that this is a really good time just to also look at your IIPP and make sure that's up to date. Again, Cal OSHA's website, it's got a model plan for the IIPP as well. So if you're going to be spending the time doing the new workplace violence prevention plan, also work on that as well. There's really an awful lot of overlapping issues and protocols that can be used in some of the training. So I think it's really beneficial to look at that in conjunction and do it at the same time. The whole aspect is the safety and the protection, you know, of the workplace from injuries, and one is violent related injury as opposed to other injuries and physical injuries. So I would kill two birds with one stone there.
Yep, that's great. Well, I'd like to thank Pooja, Vanita, and Ann. Thanks for all the hard work getting this ready. and the information out there. If anybody has any questions that we couldn't address here, we did have quite a few people on the webinar today. Feel free to email us. Happy to talk to you about setting this up for you as well. And with that, I wish everybody a good rest of their Thursday, and we'll see you on our next webinar. Thanks, everyone.